Question 436. When a new party is substituted for an existing party in an agreement, it is called an A. Assignment, B. Novation, C. Liquidation, D. Contract dischargement. Correct answer is A. Assignment. Liquidation is the process of winding up the affairs of a business or estate by converting assets to cash to pay debts and distribute any remaining balance. It's not related to the substitution of parties in a contract. Contract discharge refers to the termination of a contractual obligation, which can happen in various ways: performance, breach, agreement, etc. While a novation does discharge the original contract with respect to the replaced party, the specific term for the substitution of a party is novation. Novation involves the substitution of a new party for an existing one in an agreement. This creates a completely new contractual relationship, and the original party is released from their obligations. Novation requires the consent of all original parties to the contract. This is the transfer of rights or benefits under a contract by one party, the assigner, to another party, the assignee. While the rights are transferred, the original party, assigner, may still retain certain obligations under the contract. Crucially, assignment generally does not require the consent of all parties to the original contract, unless the contract specifically prohibits or restricts assignment. Question 437. A purchase agreement contract may be amended by A. Broker or a principal, B. Broker or an escrow agent, C. Principal only, D. Broker only. Correct answer is C. Principal only. The principals in a purchase agreement are the buyer and the seller. They are the parties who entered into the original contract and have the legal authority to modify its terms. An amendment to a contract is a change to its terms that must be agreed upon by all parties who are bound by the original contract. In a purchase agreement, this means both the buyer and the seller must agree to any changes. A broker can facilitate discussions and help draft an amendment. Brokers do not have the authority to unilaterally change the terms of the contract on behalf of their client. The principals, buyer and seller, must agree and sign the amendment. An escrow agent is a neutral third party hired to handle the funds and documents related to the transaction according to the terms of the purchase agreement. They do not have the authority to amend the contract. Their role is to follow the existing agreement and any properly executed amendments signed by the principals. Question 438. Nancy has a large tree on her front lawn whose roots, over the years, have spread onto her neighbor's lawn. The neighbor can sue Nancy on the grounds of A. Reliction, B. Encroachment, C. Nuisance, D. Covenant. Correct answer is B. Encroachment. Encroachment is a trespass onto another's property without consent, such as creation of a building, dividing wall, driveway or shrub. In this case, the roots of Nancy's tree have grown into the neighbor's lawn, constituting an encroachment. Reliction applies to a gradual and permanent loss of land due to natural causes, such as erosion. It wouldn't be relevant to tree roots growing into a neighbor's lawn. A nuisance could be a possibility if the tree roots cause significant damage to the neighbor's property beyond simply being present. However, encroachment is the more specific legal term for a physical intrusion onto another's property. Covenants are restrictions or promises included in a deed that limit the use of the property. There's no indication that a covenant is involved here. Question 439. An unlicensed subdivider may perform all of the following activities, except A. Hire a real estate salesperson to sell lots in the subdivision, B. Hire a real estate broker to set up a sales office to sell lots in the subdivision, C. Hire a publicity agent to promote the subdivision, D. Buy the land adjoining the subdivision in order to block a competitor. Correct answer is B. Hire a real estate broker to set up a sales office to sell lots in the subdivision. Someone who is not a licensed real estate broker cannot hire a salesperson to perform duties for which a real estate broker license is mandatory. Unlicensed subdividers cannot directly sell or offer to sell lots. However, they can hire licensed professionals like salespeople or brokers to handle those activities, and they can engage in other peripheral actions like promotion through publicity agents or buying adjoining land.
Question 440. The maximum amount paid from the recovery account to victims of real estate fraud is for any one transaction. A. $25,000. B. $50,000. C. $100,000. D. There is no maximum limitation on recovery account awards. Correct answer is B. $50,000. A real estate recovery account is a fund that provides financial compensation to victims of real estate professionals who have acted fraudulently or unscrupulously and are unable to pay back lost money. The account is funded by a portion of real estate license fees and fines collected by the Department of Real Estate, DRE. In California, the Consumer Recovery Account allows a person to recover up to $50,000 per transaction and $250,000 per licensee if they have been defrauded by a real estate licensee and the licensee does not have enough personal assets to pay for the loss. To be eligible, the victim must have won a judgment in court and be unable to collect from the guilty party because they are bankrupt, deceased, insolvent. If the fund pays a judgment against a licensee, the licensee's license will be suspended until they repay the amount paid by the fund, plus interest. Question 441. The following are requirements for the forming of an easement by implication. A. It must be necessary for the enjoyment of the property. B. There should be an obvious prior use. C. Both A and B. D. Neither A nor B. Correct answer is C. Both A and B. An easement by implication arises when a property is divided, and a prior existing use of one part of the property was obviously and apparently used for the benefit of the other part before the division. For an easement by implication to be created, courts typically look for the following elements. A. It must be necessary for the enjoyment of the property, easement by necessity. While some jurisdictions distinguish between easement by necessity and easement by prior use, necessity is often a key factor, especially for easements implied due to the division of a single parcel. The necessity doesn't have to be absolute but should be reasonably necessary for the convenient and comfortable enjoyment of the property. B. There should be an obvious prior use, easement by prior use. Before the property was divided, there must have been a use of one part of the property for the benefit of another part that was apparent and obvious. This prior use indicates that the parties likely intended for that use to continue even after the division. In many jurisdictions, including California, creating an easement by implication requires two key elements. First, the easement must be reasonably necessary for the enjoyment of the dominant property. Second, there must have been an obvious and permanent prior use of the easement area before the property was divided. Question 442. The holder of a note secured by a trust deed and entitled to the performance of all provisions in the trust deed is the A. Truster. B. Beneficiary. C. Trustee. D. Mortgager. Correct answer is B. Beneficiary. Trust deed. A trust deed involves three parties. 1. Truster. The borrower who signs the note and trust deed, pledging the property as security for the loan. Corresponds to the mortgager in a mortgage. 2. Beneficiary. The lender who provides the loan and is entitled to repayment. They hold the note and are the recipient of the truster's obligations. 3. Trustee. A neutral third party who holds the legal title to the property until the loan is repaid. They have the power to foreclose on the property if the truster defaults. Therefore, the beneficiary in a trust deed holds the promissory note, making them the creditor entitled to receive payments and the fulfillment of all obligations outlined in the trust deed. As the lender, the beneficiary is the party to whom the debt is owed and who gains security from the property encumbered by the trust deed. This security interest protects the beneficiary's investment in the event of default by the borrower, trustor. Question 443. FHA insured loans. A may be assumable, B may never be assumable, C are limited to 1% of an applicant's income, D are no longer made available to veterans without at least 5 years of military service. Correct answer is A may be assumable. FHA insured loans originated on or after December 15, 1989, may be assumable by qualified buyers. Whether they are veterans or not, subject to the lender's approval of the buyer's creditworthiness and ability to repay the loan. Loans originated before that date have different rules regarding assumability. FHA loans do not have a strict limit of 1% of an applicant's income. Instead, they focus on debt-to-income ratios and residual income to determine affordability. Veteran eligibility for FHA loans is not dependent on a minimum of 5 years of military service. VA loans, a different type of government-backed loan, have specific service requirements for veterans. Question 444. A house's second-floor balcony jets out from the building into the airspace of the adjoining property. It is called an A license, B easement in gross, C encroachment, D fixture. Correct answer is C encroachment. A license is a temporary, revocable permission to use another person's property for a specific purpose. It's not a physical structure extending onto the land. An easement in gross benefits a specific person or entity, not a particular piece of land. While an easement could be granted to allow the balcony to overhang, the question describes the physical structure itself, which is the encroachment. An easement would be the legal right allowing the encroachment to exist. A fixture is personal property that has become so attached to real property that it is considered part of the real estate. While the balcony is attached to the house, the issue is its extension onto a neighbor's property, not its status as part of the owner's real estate. An encroachment is a physical intrusion onto an adjoining property. In this case, the second-floor balcony extends beyond the property line and into the airspace of the neighboring land, which constitutes a physical intrusion. Question 445. Tenant Tom has a year-long lease expire, but wishes to stay in his apartment. So, he continues to send rent checks to his landlord. Until the landlord moves to evict Tom, A exists. A. Tenancy at will, B. Tenancy at sufferance, C. Tenancy in common, D. No tenancy exists, the lease has expired. Correct answer is B. Tenancy at sufferance. A tenancy in common is a form of co-ownership of property where each owner holds an undivided interest in the property. It is not related to a landlord-tenant relationship after the expiration of a lease. This type of tenancy arises when a tenant who legally possessed the property under a lease remains in possession after the lease has expired without the landlord's consent. The tenant is essentially holding over unlawfully. In the situation described, tenant Tom's year-long lease has expired. His continued occupancy and sending of rent checks do not automatically create a tenancy at will if the landlord has not explicitly agreed to his continued occupancy. Until the landlord takes action, either accepting the rent and thus potentially creating a tenancy at will or taking steps to evict, Tom is considered a tenant at sufferance. Distinction from tenancy at will, the key difference lies in the landlord's consent. A tenancy at will is created by the express or implied agreement of the landlord to the tenant's continued occupancy after the lease ends.
A tenancy at sufferance exists due to the tenant's unlawful holding over without the landlord's agreement.